don't we? They're just the most fun things of all. Um, right, that's probably said in a little jest. Hi, Phill Brunner here again from Bailiwick Legal. Today's topic is just dealing with that distinction. I was just making fun of it, of what is a casual versus a permanent employee. And so, usual things. We're not giving out legal advice here. If you need further assistance in relation to what is going to be said during this session, please contact us and we can assist you through that. So, I guess from a historical point of view, my background has actually been in employment field for way too long, 30 plus years dealing with that. I actually did law to get out of doing employment related work, and here we are talking about casuals and permanents. And I have to say, throughout my association with WA farmers as well, and generally dealing with the farming community, contracts of employment and this distinction between a casual, what is a casual and what is not a casual, is something that has come up very, very frequently. So typically in the context that I'll get a call from an employer and they'll say, I've had this farmhand working for me for the last 3 years, he's a casual, blah, 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 and on it goes. And I start thinking to myself, been there 3 years, probably working the same hours every week, probably getting a bit of time off when they want some time off, probably actually being provided with accommodation, and you're saying this person's a casual. Some of those things don't actually compute. Anyway, that's sort of the nature of the discussion for today's session. Probably the interest has peaked in the context of casuals because of some decisions coming out of the federal court over the last 2 years, and changes that have been made to the Fair Work Act, I think late last year, if not early this year, to do with casuals, and more particularly how casuals are defined in a statutory context, which is a tiny little bit different to the common law context. So the main decision which has sort of given gravitas to this issue is WorkPac and Risata. Now, that's a case that travelled through, I think, from the Federal Circuit Court to the Federal Court and then to the full Federal Court by way of appeal, and it stopped there. I think leave to appeal was denied to the High Court. So we have a decision of the full Federal Court which, in this case, gave some pretty good parameters for what is a casual employee. Now, personally, I don't think the court's gone outside of what history and historic cases have told us a casual employee is, but others will take the view that the court has extended the definition of a casual. Well, what did the court actually say? The circumstances of this case are obviously unique, but not actually dissimilar to a lot of engagements, typically in the sort of construction, building industry, sometimes in the mining sector, often in the farming sector, and also quite predominant in tourism industries, where a lot of people are given this term casual at the commencement of their employment engagement, but may in fact be then engaged for years, sometimes 10 plus years. So in Risata, the person was engaged under a series of contracts. The person was not actually engaged by, this is Risata by the way, was not actually engaged by the mining company. It was engaged by what I'll call a labour hire entity, in that the labour hire entity supplied his services to the mine site along with those of very many other people. And as I said, there were quite a number of different contracts of engagement, pretty much rolling on one after another He was he was called a casual. Each of those contracts called him a casual. Some of the other relevant facts was that he was part of a roster of work, and that roster was set for 12 months. And he worked consistent hours. Whilst on the roster, he would be working consistent hours week in and week out. I don't think it was fly in, fly out concept, but it might have been something like 2 weeks on, 1 off, or something like that. Very structured work hours is really the point I'm trying to make there. Given that sort of background, and provided accommodation as well. In the context of all that background, the court looked at various indicia, and some of those were whether the contract provided for the employment to be regular or intermittent, whether the contract permitted the employee to elect to work or not. And in that context is that in a casual sense, it's an offer for work, and that offer can be accepted or rejected. So in the Risata situation, this person was on the roster. He had to turn up for work when required to do so pursuant to the roster. He didn't really have the ability to say, no, I'm not going to work on that shift. The duration of the employment and whether it was a stipulated time period, and we've discussed that. The Risata was there for several years, as it turned out, and had a forward roster, which he was required to meet. Another indicia is whether someone's actually paid on an hourly rate. I think in Risata he was actually paid on an hourly rate based upon the hours worked each shift. And one of the key factors in this case itself is whether the person was paid a casual loading, in the sense of not just saying that the hourly rate includes a casual loading. What the court really said in this situation was the casual loading needs to be actually defined in and separated. So in the pay sheets, it's not just expressed as an hourly rate inclusive of a casual loading. It's actually expressed as, $44 plus 25% casual loading, and maybe sums allocated to that. And in the contracts of employment, similarly, there's a distinction between the base rate and a casual loading rate. None of the contracts he was under actually created that distinction. And so one of the arguments in this case, and it's an interesting study because it shows up I think a gap that a lot of farming businesses might need to be seriously wary of. Risata was being paid $55 per hour, which on their case included the 25% casual loading. However, the court said, through a range of legal arguments based upon provisions in the Fair Work Act, and the fact that casual loading was not actually separated out, the court basically said, well, the annual leave and sick leave now being claimed by Risata is payable at $55 per hour. So that basically took away the company's argument. The company was saying, well, the 25% loading we've been paying him as a casual should offset the annual leave payments. And the court said no. For a range of reasons, that's legally not possible. So Workpac was ordered to pay annual leave and sick leave accrued rights to Risata at $55 an hour. As I said, that's quite an important issue in itself, and nothing, no clear example comes to mind, but if in a farming context an employer is paying someone, let's say, $28 per hour inclusive of a casual loading in lieu of annual leave, etc., and just pays that hourly rate, doesn't typically have a written contract of employment, which is a prevalent issue within the farming sector, then in those circumstances, if someone turned around after year 3 and said, "Oh, I want 12 weeks annual leave, thanks very much," paid at $28 an hour, that employer has really got nothing to stand on in defence of that claim. So a couple of things there, a couple of very important points there. 1, have a written contract of employment. 2, if you've got a casual employee and you're thinking that person is going to be with you on a long time basis, be very wary about how you distinguish between the base rate and the casual loading. Before you even get to there, you've got to start thinking to yourself, if I need this person for more than, say, 3 or 4 months, should I actually make them a permanent from day one? And you don't then have all this problem. So, following Risata, and I think there might have been one other case in the federal court system which sort of followed and adopted Risata, the Commonwealth decided to, in its wisdom, to make some changes to the Fair Work Act to try and deal with this issue of what is a casual. The changes, I have to say, those changes to the Fair Work Act don't actually go to that conundrum about whether the casual loaded hourly rate should be payable whilst, for annual leave entitlements or not. It went to this primary definition of what a casual is. And so we now have Section 15 capital A inserted into the Fair Work Act, which defines a casual. And I'm going to read this, so if I'm not looking directly at camera, I'm looking at the screen of my computer here, which has got this definition on it. So 15A says, a person is a casual employee if an offer of employment is made by the employer to the person is made on the basis that the employer makes no firm advance commitment to continuing and indefinite work according to an agreed pattern of work for the person. Now, a bit of a mouthful, but it encapsulates some of the things that I've just gone through dealing with the indicia of what is a casual. So it makes no firm advance commitment to continuing and indefinite work. And this brings it back to really what the courts have said is a true casual. Someone who does not have an expectation of working tomorrow, let alone next week, has not got this indefinite work timeline. And so as a true casual, what you would be doing, you would be calling a person at, say, 8 o'clock in the morning, maybe 7 o'clock in the morning, say, can you come and work today? And the person then has the ability to say yes or no. If the person says yes, you say, great, I've got work for you today, come and work. At the end of the day, that's it, engagement complete. If you want that person to work then the next day, it's the same proposition. The next morning, can you come and work? The problem you've got, of course, that is if that's going to be a continuum, 5 days a week for the next 6 to 12 months, well, day one you're saying, I've got 12 months worth of work. Do you want a job? And so you've got to be a bit careful there. Departing back to the definition. So a person is a casual employee if the offer is made, etc., etc., and the person accepts the offer on that basis. So the person accepts the proposition that there is no continuing indefinite work pattern here. All right, and that's quite an important thing too, and it imports this process of mutuality. Now, the easiest way of dealing with this is in a written contract of employment, and we typically develop our casual contracts for farm businesses on the basis of, if they're a casual contract, we will have certain provisions in the contract. We're not providing a warranty about further work. We're not providing a warranty that there'll be a job tomorrow. We're not providing, an offer of employment indefinitely. And then on the flip side to that, you've got statements that the employee acknowledges and agrees that it's not an ongoing and indefinite job, agrees that there's no proposition that work will be continuous. And so your contractual environment then becomes quite important and mirrors that mutuality of agreement. So the Section 15A also deals with 4 factors in determining whether, and I'll come back to this concept of no firm advance commitment and indefinite work according to an agreed pattern of work. In looking at those terms, the statute says that we're to consider whether the employer can elect to offer work and whether the person can elect to accept or reject work. We've covered that ground. The second one is whether the person will work as required according to the needs of the employer, and this imports that concept of continuity of work. All right. And the third reason is whether the employment is described as a casual employment. This perhaps imports one of those other sort of quirks within employment law, where the law says it matters not what you've called the relationship. You could call it a casual relationship, but the law will actually look at how it's worked, how all those bits and pieces fall together, and make a determination that it is or it isn't a casual. Right? Simply by calling that engagement casual does not make it so. And the fourth criteria is whether the person will be entitled to a casual loading or a specific rate of pay for casuals under typically an award. And so we have a definition in the Fair Work Act which is meant to sort of work with the award system. In most federal awards now, and this applies in the pastoral award as well, there are what's now known as the sort of casual conversion provisions. In a nutshell, that means, those provisions provide an entitlement for a person who has been engaged on a casual basis after a period of 6 months, I think it is, to seek from their employer to convert to a permanent status. And so, as I said, these provisions really then facilitate that discussion between the employee and the employer about, well, what truly is the status here? I've been engaged for the last 6 months on a regular, it's 12 months. So I've been engaged for the last 12 months on a regular and sort of systematic basis as a casual employee. Clearly, I have an expectation of continuing to work, and that expectation is indefinite. I'd like to now convert to a permanent employee. And the employer is obligated to seriously consider that request, and to then deal with that request. and either convert the person to a permanent, or if the employment is not ongoing and continuous, to maybe do something about severing that employment. Now, in my mind, this raises a bit of a conundrum. You've got someone who's theoretically a casual, working for 12 months on a regular and systematic pattern. Will the courts really say, well, that's not a casual, that's someone who's already permanent? But I think there's some safeguard in the Fair Work Act and the award system, such that you could, I'll say, get away with engaging someone on a casual basis, although that may be regular work, for a period of 12 months, and then, sever that relationship. Ordinarily, I'd say, well, that's all good and well. Fine, go out there and do that. I think the problem you may then face is if that once the person's sort of gone beyond 12 months, and you say, well, sorry, no further work, simply to relieve yourself of that decision as to whether they're to be permanent or not, you may in fact find yourself with an unfair dismissal claim, or an adverse action claim. So I don't think it's in employers' interest generally to be looking to exercise some unilateral provision to engage someone for 12 months on a casual basis, thinking that they'll just get rid of them at the end of that period of time. That's probably going to amount to a few adverse claims against the employer. So, distilling all that, what do we get out of that? We get a position where, one, you should actually think seriously about how, about when you're looking at the need for additional labour, you should be making an assessment as to whether that labour is to be ad hoc or you require that labour on a more permanent basis. Now, in farming and tourism, I think it is possible to structure contracts on the basis that someone could be a casual for a set period of time or a set task. The easiest tasks that come to mind in farming is obviously seeding and harvest. Right? Yes, it's going to be regular engagement. Yes, the work pattern will likely be the same week in and week out, but it's for a set period of time or it's for a set task. And in those circumstances, I think it's possible to structure a contract in writing with a person to establish that that person is in fact a casual employee for that task or time. And my view is that that would facilitate and fit within the provisions of the Partial Award as well as the Fair Work Act. Of course, if you go beyond that set task, if you continue the person within employment once that task or time has finished, then you've crossed a barrier and the person's likely to be a permanent employee at that point in time. Every circumstance will be different, but you just need to be wary that if you've engaged someone for a set period and a set task, sever the relationship on that event and don't flip that person onto a continuing contract. So what else have we learned? We've learnt that once you've made that assessment, if someone is to be engaged on a casual basis, their engagement is ad hoc. Their engagement is intermittent, leaving aside the examples I've just identified, and they do have the ability to say no to you. I probably need to raise a distinction here too, because it's just occurred to me that within the shearing industry, Part 7 of the Partial Award, they're deemed casual employees pursuant to the award anyway, and their rate does include a casual loading. And so my comments aren't directed to that environment because that is quite unique and quite different. Okay, once you've identified that the person is a casual, no ongoing commitments, intermittent engagement, it's wise also in the written contract to have those warranties and representations reciprocated, and in the contract it should be stipulated that there is a base rate, there is a 25% loading on top of that, and people don't think it's 20% anymore. It hasn't been 20% for at least 10 years. So it's a 25% loading. And that loading should be reflected also in the pay sheets and the pay records that you're required to actually keep. As an aside, I'll just flip into a short thing too. Some changes to the Fair Work Act made, again, within the last 2 years, reverse the onus about pay records. And basically, if the employer cannot produce pay records, the court will accept what the employee is saying about the hours they worked and the days they worked. All right, bear that in mind. So the necessity to keep records, pay records, hours worked, days worked, payments made is absolute. You've got to do it. And if you don't do it, it can come and bite you. All right, I might have said enough on this one, I think. The casual concept, at a very base level, is pretty straightforward. My experience is that it's quite consistently abused within the farming community and within tourism. And when I say abused, it's not derogatory. It's people have been used to a particular system and work with a particular system, not really understanding or knowing or being provided the right advice in respect of what they're actually doing. So if you have a need to engage employees in the future, and with farm sizes growing, I suspect that need will also grow. Automation's another issue that will impact on that too, though. Then it's wise to actually get some advice. Getting your employment contracts locked away in a proper form suitable to your business is, in my view, a prerequisite. And it's an easy risk management tool, and it's not costly. So it's a wise exercise to do. All right, I'm going to finish it there. As you know, Bailiwick provides consultations of up to sort of 30 minutes or so to deal with basic issues, and let's hope we can help you in some of those things. If you need further advice in relation to casuals or employment contracts generally, please just give us a call. Bailiwick and Dry Kirkness will be undertaking some succession seminars coming up on the 23rd of June, so this week, Wednesday evening at Muresk, and on the 1st of July, which I think is a Thursday evening, down at Mount Barker. So please check our websites for those events. I will also be, me and a few from the team here will also be at the WA Farmers Conference at Muresk this Thursday and Friday. So hope to see you come along. All right, thank you very much. Take care and see you later.